Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan, Good afternoon, Selamat siang, best wishes to all of us. We wish to welcome the Honorable Deputy Secretary General of UNIDROIT, Professor Ana Veneziano, the Honorable Legal Consultant of UNIDROIT, Mr. Hamza Hameed, the Honorable Dean Faculty of Law, Universitas Padjadjaran, Bapak Dr. Idris SH MA, the Honorable Head of Transnational Law Department of Universitas Padjadjaran, Ibu Dr. Prita Amalia SH MH, and the honorable participants. Good afternoon, ladies and gentlemen. Welcome to the webinar of Public International Lectures. My name is Adiana Bella Putri, and I will be your Master of Ceremony for this webinar. It is an honor for me to have the presence of this event. On behalf of the host, we would like to extend our greatest appreciation to each and every one of you for being able to attend this webinar. Ladies and gentlemen, please allow me to inform you of this afternoon program. Today's webinar will carry out the topic about Principle of International Commercial Contract 2016 and Transnational Business Transaction UNIDROIT Perspectives, including Cape Town Convention, which will be presented by our amazing speakers from the International Institute for the Unification of Private Law, or UNIDROIT. The aforementioned topics will be delivered by Prof. Ana Veneziano, Deputy Secretary General of UNIDROIT, and Mr. Hamza Hameed, the Legal Consultant of UNIDROIT, followed by a Q&A session, which will be guided by the moderator, Madam Dr. Prita Amalia SH MH. Before we start our session, please allow me to explain some of the webinar guidelines. First, please mute your audio during the session. You may activate your audio during the Q&A session. Second, we recommend you to activate your video. Third, please allow the instructions to change your username, which is your name _ your institution. Fourth, you may deliver the question through chat, and if you wish to deliver it directly, please use the raise hand feature in the participants menu. Ladies and gentlemen, moving on to our next agenda, we will have some welcoming words delivered by Dean Faculty of Law, Universitas Padjadjaran, Bapak Dr. Idris SH MA. To the Honorable Bapak Dr. Idris SH MA, the screen is yours, Pak. You may start the welcome speech now, Pak Idris.
Pak Idris, you need to unmute.
Okay, thank you. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. All the praises and thanks be to Allah, the Lord of the world. Good afternoon, ladies and gentlemen. Today, of course, we are very happy because the Transnational Business Law successfully invites the international prominent lecture, not only for us, but of course this is the good for a student. So welcome to our faculty, Professor Ana Veneziano, Deputy Secretary General of International Institute for the Unification Private Law, what we call UNIDROIT. UNIDROIT is not something new for us. I'm sure that so many people or even students have know about the UNIDROIT. And also Professor Hamza Hameed, legal consultant, UNIDROIT. So thanks so much for the department, for my colleague here also, my senior, Dr. Rika, also here Prof. Bayu, yeah. Prof. Bayu, and of course, this is the great lecture because has been attended by more than 2010. Yeah. So again, thanks so much, Prof. Ana, Prof. Hamza. Hopefully, this is not the first one, but hopefully, of course, the lecture can be followed by bilateral agreement in academic activities. Like, for example, maybe later we can make a draft MOU or bilateral agreement in terms of how to make our cost healthy from the perspective of the practitioner, yeah, because this is good for a lecturer because we have a subject on relevant the topic, yeah, international private law. So for my student, please you can take advantage for this lecture because this is positive impact, yeah, of the pandemic, yeah. So easy to invite or to give lecture, so we can take benefit, and also please you can arrange, you can ask, you can discuss with the prominent lecturer, not only for a final assessment, but for example for joint seminar, joint writing, yeah, because now UNPAD is still effort to make a better of ranking, the word university ranking, yeah. So again, thanks Prof. Anna, Prof. Hamza. Thanks a lot to my colleague, Dr. Prita, Pak Mursal, Dr. Rika, Halita, and of course my young colleague, yeah, Pak Mursal, Pak Taufik, and of course other lecturer. Again, thanks so much. I open officially the lecture. Good luck for you. Hopefully this is a great lecture. Thank again. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Bapak Idris, for the welcoming speech you have delivered. Ladies and gentlemen, before our main session, we are going to have a photo session which will be guided by the host. To our honorable participants, please turn on your camera. To Darian, you may guide the photo session.
Okay, thank you, Adiana. Since we have nine slides, we'll be taking 9 pictures. So all participants, please turn on your cameras. Again, so all participants, please turn on your cameras. Okay, we'll be taking our pictures now, starting from now. So the first picture in 3, 2, 1. All right, the second picture in 3, 2, 1. My apologies, there's been a slight error in the picture. So the first picture in 3, 2, 1. My apologies, apparently there's been an error. Adi, could you back up and take the picture?
Okay, I trying to back up Darian. So this is the second second screen on my mark 3, 2, 1. Okay, this is the last screen on my mark 3, 2, 1. Okay, thank you very much.
Thank you very much. Thank you very much, Pak Taufik, Darian. Ladies and gentlemen, our seminar session will be guided by Madam Dr. Prita Amalia, SHMH, as the moderator. It is now my pleasure to introduce our moderator. She has been a permanent lecturer at the Faculty of Law Universitas Padjadjaran since 2006, and particularly in Transnational Business Law subject. She is acting as head of Transnational Business Law Department, Faculty of Law, Universitas Padjadjaran. Furthermore, she made a research about implementation of Cape Town Convention in Indonesia. She also has a lot of experience for being speakers at several international conferences and actively participate in international networks. I would like to hand over the session to Madam Prita Amalia. To the Honorable Madam Prita Amalia, the screen is yours.
Okay, thank you, Adiana, for the introductions. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. good morning from Roma for Roma and good afternoon for Indonesia. And welcome to the International Public Lecture held by the Transnational Business Law Department, Faculty of Law, Universitas Padjadjaran. And thank you for Dean Idris for coming and also for the welcoming remarks to start this event. We would like also to welcome all the speakers, prominent speakers from the UNIDROIT. It's really honor for us to have Professor Anna Veneziano and Professor Hamza Hameed from the UNIDROIT. It's a great opportunity for us to directly get the lecture about the UNIDROIT principles on the Principles International Commercial Contract 2016 and the Cape Town Conventions. And we would like to welcome as well for all the participants. We are looking here, there's numbers of lecture from the other university in Indonesia, and also welcome for all the participants, all the students coming from the Faculty of Law, Universitas Padjadjaran, and from the other university. We are in the International Public Lecture with the UNIDROIT, and we would start this event by get the lecture from the Professor Anna and Professor Hamza Hameed. The lecture would be conducted in the 45 minutes for each speaker, and all the participant has an opportunity to raise the questions by put the questions in the feature Zoom chat feature or by using the raise hand feature. And before we start this session, please allow me to read the curriculum vitae Professor Anna Veneziano. Hello, Professor Anna. Good morning.
Good morning, good afternoon to you.
Good afternoon. And thank you for being here with us virtually. Hopefully in the next year you could visit us physically in Indonesia, Universitas Padjadjaran. We usually met in the Cape Town Conventions academic project in Oxford on 2014 and 2018. And today we have an event with Professor Anna. Professor Anna Veneziano is a Deputy Secretary General of the UNIDROIT. She is a Professor of Comparative Law at the University of Teramo, Italy, where she was formerly the Director of the Department of Private Law. In the period 2013 until 2017, she was tenured Professor of the European Property Law at the University of Amsterdam. Her educations get a law degree with honors from the University of Rome, La Sapienza, and LLM degree from the Yale Law School, and PhD degree from the University of Florence. Her main research and publications areas are on secured transactions, include Cape Town maybe, as well as the international, comparative, and European contract sales law. So today event, Professor Anna will deliver a lectures about the UNIDROIT principles of the International Commercial Contract 2016. And before that, we would like to introduce and say hello to Professor Hamza Hameed as well. Hello, Professor Hamza Hameed.
Good afternoon, good morning.
Good afternoon and good morning to you in Rome. Professor Hamza Hameed is a lawyer working as a legal consultant at the UNIDROIT. His primary focus is on secured transaction law, fintech, whereby he works on the Cape Town Conventions and its protocol, with a particular focus on spare-craft financing, as well as UNIDROIT project on digital asset and private law. He is closely involved in the activities of the Cape Town Conventions academic project and the manager of fundraising and administrations at the UNIDROIT Foundation. He holds an LLB from the University of London International Program and an advanced LLM degree in Air and Space Law from the International Institute for Air and Space Law at the Leiden University. He is also the lead of the legal team at the Space Generation Advisory Council and member of the International Institute for Space Law. Today, lecture, Professor Hamza Hameed will be delivered about the Cape Town Conventions. As we know that this convention has ratified by Indonesia, has numbers of the protocols. First of all is aircraft protocol, space protocol and railway protocol, and coming with the MAC protocol, mining, agriculture, and constructions protocol. Before we start, maybe we believe that all the participants has been informed that Indonesia is one of the UNIDROIT member by the President regulations on 2018, and there's numbers of the UNIDROIT conventions discussed, and one of the convention is Cape Town Convention related with the Indonesia. And for your information, Prof. Anna and Professor Hamza, there's numbers of the participants as well from the aviation industry. Maybe we'll directly discuss in the discussion session, because about both UNIDROIT principles of the international commercial contract, especially about the hardship, is really relevant with the COVID situations, as well as with the implementations of the leasing agreement on the aircraft financing. Maybe without further ado, we would like to please Professor Anna to deliver the lecture for 45 minutes at the first session, and we'll be following with Professor Hamza Hameed. And participant could participate in the discussion session by using the raise hand or the feature chat. Professor Anna, the time and screen is yours.
Thank you very much, Dr. Prita, for this kind introduction. I am extremely pleased and extremely honored to participate in this lecture together with my colleague Hamza Hameed. And I would like to thank the University of Padjadjaran, I hope I have pronounced it well, and also the Transnational Business Law Department, and particularly the Honorable Dean for participating in the opening, and you, Dr. Prita, for your participation, organization, but also interest in the activities of UNIDROIT. I would like also to recognize Professor Bayu, who has been so active in a number of UNIDROIT instruments, including the UNIDROIT principles and the UNIDROIT FAO IFAD legal guide on contract farming. And of course, thank you so much to Taufik and to everyone for making this happen. I am particularly pleased to be here, also because, as you know, Indonesia is one of the member states of UNIDROIT, is the latest member state that joined the organization, and we have a special bond, not only because Indonesia has ratified some of our instruments and seems to be particularly interested in what we do, but also because as a member state, we are keen to develop excellent relationships with academia and with the government and with the practicing community. So, but without further ado, allow me to start with my presentation. And so this is it. From the beginning, and here we will be talking about the UNIDROIT Principles 2016, which is the latest edition of this set of internationally developed general rules on contract law, which contain balanced and practice-oriented solutions sanctioned by intergovernmental organizations such as UNIDROIT. And you see here that the whole version is available in English on our website, but also in many other languages. And so before doing that, however, I know that you already know UNIDROIT, but this is just a very quick slide to recall what UNIDROIT is and what it does, and maybe also to have a look at the at this map and see how important and strategic the position of Indonesia is for us in the membership in the world, in your part of the world. So we are counting on you in this respect. So what we do, of course, is develop methods for modernizing, harmonizing, and coordinating international private and commercial law. We have a number of international uniform law instruments today we will have a look at two of them that you have already, I think, addressed in some of your programs. One is a soft law instrument to facilitate commercial transactions, particularly the drafting, the development, but also the solution of disputes for international commercial contracts, and it's the UNIDROIT principles. And the other one is a treaty, a system of treaties, so a completely different type of instrument, a hard law instrument, but a special kind of treaty. And so this is why we would like to talk about it, because it's extremely important from a practical point of view, and it was tailored to have this economic benefit. Now, here, as you see, there is a list of the different areas where UNIDROIT is currently active. I thought it might be interesting for you to not only have this list. You see, of course, the international commercial contracts, international access to finance, where you have the UNIDROIT principles and the Cape Town Convention, but also the sector of agriculture, the sector of capital markets, civil procedure. One section which is very important for us, but it's not directly related to traditional commercial law, which is the protection of cultural property with the UNIDROIT Convention on Stolen or Illegally Exported Cultural Objects, which is gaining member states every year. The new sector of new technologies and digital assets, and another new sector, banking law and insolvency. So you see a lot of possible topics where you might have an interest. And on this slide, I would not like to go through it, but I would like just to underline three things. The first is, you see that there are many colors, and the light green and the darker green. So this is just to underline that the darker green are the hard law instrument in the traditional sense, the treaties. And the other ones are the different types of softer instruments, from the model laws, which of course would like to become hard law in national law, to much more flexible instruments tailored to be then adapted to the needs of certain regions or certain legal systems, like principles or legal guides or legislative guides. And you can see from this slide that the light green is prevailing. So this is one trend that I would like to underline. In all intergovernmental global organizations, we tend now to develop soft law instruments more than treaties for a number of reasons. One being that developing a treaty is very difficult. We have been quite successful in 2019 in approving the last protocol on the Cape Town Convention, the Mining, Agriculture and Construction Protocol, which will be discussed by Hamza. But this is an exception to the rule, that usually now we tend to develop soft law because it's easier to reach uniform solutions, and because it's easier for legislators and parties to tailor that to their own needs. And the second thing that I would like to underline is the fact that we have increased our cooperation with other intergovernmental organizations and specialized international organizations. This is another feature that we have in common with other organizations, and I would like to underline it because, of course, each organization has its own strength, but we, for example, are very specialized in technical knowledge and also with a strong academic participation. Other organizations are on the field, so they can do technical work. They know also, they have knowledge of economics and social issues. So we tend to pair with them. And we even have a new work program item together with UNCITRAL, which is the first time ever that we have a joint project with UNCITRAL on the model law on warehouse receipts, as you see in the part on international access to finance. And the last point I would like to underline, you see new work program. Where you see new work program, they are the new projects that we're still developing. So maybe more interesting for you to know where we are working now. Model law on factoring, model law on warehouse receipts, legal structure of agricultural enterprises going on with the work of agriculture, and then also best practices for effective enforcement of creditors' rights, principles of digital assets and private law, and insolvency of small and medium-sized banks. I think all of them might be of interest to a transnational business institute and to the students and to the lecturers and professors who are here. But I would like to go to our UNIDROIT principles, and I would like to start with a practical example, because what I would like to show is that the UNIDROIT principles as a soft law are an extremely versatile tool. And I would like to underline the word tool. So they are not the answer to all questions. They will never supplant the application of domestic law, but in international contracts, they can be and have been extremely useful in specific instances, because they can be used in very different ways. So they are a powerful tool, in a way, a weapon in the hands of lawyers, advising clients. So if you are a lawyer and you want to be a transnational lawyer, knowing the UNIDROIT principles can be an incredible asset for you, and also for adjudicators. Judges in national courts, we will see even judges in national courts, but also, of course, arbitrators or mediators, everyone who is trying to settle disputes or solve disputes. So this is why the UNIDROIT principles are so useful. So we start with this example. Here we have a series of contracts between an English company and a government agency of a Middle Eastern country for the supply of equipment. And some of the contracts had a rather wide description of what would be the applicable principles according to laws and principles of natural justice. And why does this happen? You probably know that in this situation where the legal systems are different and parties cannot agree on applying one of them because it would be foreign to the other party, or because the other party would not like to apply it, then the parties may decide to apply a neutral legal system. And sometimes they do choose one law which is considered to be particularly good for international commercial contracts. For example, this is what one says of English law many times, because it is a very practically oriented legal system in many respects. Or else, for example, I'm just choosing another one, common in arbitration, Swiss law, because it's considered to be balanced, and a civil law tradition. So maybe this might be useful. But all these are domestic legal systems, so you have to know about them. And also they are not always tailored to international commercial contracts. For example, even English law has rules in, for example, the validity of contracts, the supervening circumstances, what happens, and we have seen with the pandemics how important this having good rules for that is. Sometimes there is a very rigid approach of the English law on this matter. And so this is why parties may prefer to not to apply a specific domestic law, but to refer to principles of international commercial law. But the principles, this reference is very general. So the UNIDROIT principles were seen as the way to concretize them. Such general rules and principles enjoin international consensus reflected by the UNIDROIT principles. And so this is an example that I wanted to make, taken from a real case, in order to show what is one of the instances where the the soft law set of rules can be particularly useful for the parties and, of course, for the lawyers advising the parties. Now, we come, however, to the origin and developments of the UNIDROIT principles. I would like to be quite quick on this because you might already know something about it. You know that they were first published in '94, but there is a very long history before that. And this history rests on big shoulders. The big shoulders are all the work that was done at UNIDROIT at the beginning of last century, Ernst Rabel and other people working on international sales law. And then all this work went to UNCITRAL and it developed the CSG, the Convention on International Sales. And the convention was a model for the UNIDROIT principles as well. The study group was developed from the 80s onwards on the basis of comparative research, participation of experts who had a background in different legal systems, but they were sitting there in their personal capacity. And now we have a translation of the UNIDROIT principles in many languages of the world, which makes them even more useful. And what do they cover? You probably also know this. It's a very wide area of subject matters that in some legal systems are both in the area of contract law and in the area of obligations, more general obligations. So we have formation, pre-contractual phase, interpretation, which is an extremely important part of the rules of contract, validity, legality, performance, non-performance remedies, excuses for non-performance and hardship, agency, third-party rights, and then all these more general topics of obligation law, such as set-off, assignment of claims and transfer of obligations, limitation periods, practically very important, and the big area of restitutions. And the latest edition has also included some special rules and comments regarding the application of the UNIDROIT principles to long-term contracts. So the idea is that this is general contract law. And one of the things that I would like to underline is also the terminology, because the UNIDROIT principles, together with other international instruments, has had also this effect of developing a common terminology in English that we are now using currently also to refer to these subjects in other contexts. So UNIDROIT principles as a kind of background law influencing the academic debate and the development of other international instruments. So before going to the various applications of the UNIDROIT principles and also some case law that might be interesting for you, I would like to focus on one of the topics that I have heard is particular interest for you, because, as you know, the UNIDROIT principles contain substantive rules on contract law, and some of them are common core rules that are already accepted as a kind of common core of contract law all around the world, especially for international contracts, because they were already contained in the CSG, because they have migrated into many different legal systems through reforms, recent and less recent reforms. So, for example, many rules in the formation of the contract, offer and acceptance, revocation of offer when the contract is concluded, but also in the remedies, damages, for example, general rules on damages, what happens if you want to terminate a contract and the limitations to that. This is something that can be considered a kind of common core. But there are also quite a few rules in the UNIDROIT principles that are innovative. They are innovative because the legal systems do not contain harmonized rules on these subject matters. However, those subject matters are particularly important for international commercial contracts and I would say for contracts in general, even in domestic law. And one of those areas of the law is how to respond to supervening circumstances arising after the conclusion of the contract that would alter the equilibrium of the contract. And here I'm reading the definition of hardship of Article 622 in the UNIDROIT principles, either because the cost of one of the performance of one of the parties has increased, or because the value of the performance the other party receives has diminished. So there is a very strong imbalance created after the conclusion of the contract. What do we do? Is there an answer in the legal system? Or is it true that we have to leave the situation as it is, and therefore the burden will be only on one of the parties? And well, we know, and I'm not going into this because we don't have the time to do that, you know that legal systems have different approaches, and from a sort of rigid approach to say pacta sunt servanda, we have to keep the contract as it is, unless you have a clause in the contract allowing parties to do something in this situation. A hardship clause, for example, like the ones developed by the International Chamber of Commerce, which, by the way, has been heavily influenced by the UNIDROIT principles in the latest edition of 2020 that was published last year. So this sort of very rigid approach to hardship. For example, for some aspects, this could be English law, even if there are exceptions, or the old French law. And then we have other systems that allow for some changes in the contract, renegotiation by the parties, or also sometimes the possibility for a judge to intervene and in the contract by restoring the original equilibrium. Now, especially the part on the negotiation has been particularly important for many legal systems and for many judges interpreting the legal systems, also because of the effects of the pandemics and the legal restrictions introduced by them, because this is a way to give parties party autonomy, to underline the importance of party autonomy, but also to underline the importance to keep the value of the contract instead of destroying the value of a contract, especially a long-term contract, when it is possible that parties reach an agreement on different circumstances. So this negotiation in some legal systems was based on a principle of good faith, a principle of solidarity, but the UNIDROIT principles have a specific rule, and so they give more concrete advice on how this could be done. And this is what I wanted to show. First, exceptional circumstance, contract to be observed. Secondly, what is hardship, exceptional situation. Third, effects of hardship. First, right to renegotiate the contract, and then the possibility that a judge either leaves the situation as it is or terminates the contract or adapts the contract with a view to restoring its equilibrium. So of course, here we could discuss a lot, but the important thing to notice is that this is very flexible, it respects party autonomy, and it's also very important to keep the value of the contract and as a risk-sharing way of solving situations such as this. But I will go to this slide, which is the ways to use the UNIDROIT principles. And on the basis of this slide, we will then look at some case law. So again, this is the message that I wanted to convey. The UNIDROIT principles are a tool, a versatile tool for the parties. First of all, they can be chosen by the parties as the law governing the contract or as a content of their contract. I'll go back to this. then they have been also used as guidelines for drafting international contracts, and the fact that they are written in many languages helps in this regard. Or, and this is quite an important way, the UNIDROIT principles have been useful and can be useful as guidelines to reach settlement agreements between parties. And I have a case, an example of that. Then there is the possibility to use the principles as a tool for adjudicators. Now, we have to say that when the principles were developed, the first aim was that the principles would be used in arbitration. And therefore, because arbitrators are much freer than judges to choose, usually to choose the applicable law to the contract, and we'll see this in a very short while. But according to the preamble of the principles and also to some case law, the principles can be applied by an adjudicator also when parties did not choose any applicable law, but it was clear that they meant to exclude the application of domestic law from the way that they had developed their contract relationship. And there is another way the principles have been used, which has a bit surprised the original drafters, but it's now one of the most common ways that the UNIDROIT are referred to by judges, especially domestic law judges, which is to interpret or to supplement the applicable domestic law. And I will go back to this example in a very short while. Of course, they have also been a model by national and international legislators. Most recently, for example, the French reform of contract law of 2018, I'm sorry, in 16, but also, for example, some provisions in the Chinese civil code and in other civil codes. Maybe there you have information about also your region, and much more than I could have. So, of course, we are here at a university department. We know that the UNIDROIT principles are extremely useful as teaching materials. Now, this is where you can find case law on the UNIDROIT principles. There is a free database. It reports now 536 cases that refer to the UNIDROIT principles. We have some problems in locating arbitration cases because they are not always accessible, and especially the ICC cases, which are important. We know for a fact that the principles were cited, but we don't have the case and we cannot put it in the database. But actually, it is possible here to have a look at many cases in English with an abstract, and if possible, with the original text, and with the possibility to do a search on certain topics, specific topics. Now, allow me to take one example, just to show how the UNIDROIT principles can be applied in practice or have been applied in practice. Here we have a typical situation where the UNIDROIT principles could be useful, because we have a contract between a Turkish company and a company incorporated in one of the states of the West Indies, which involved a highly sophisticated equipment. The contract had choice of law clauses, but as you know, sometimes the choice of law clause is put at the end. It's not really thought of so much by the parties. And in this case, there were two conflicting choice of law clauses. One was in favor of English law, and the other one was in favor of Swiss law. Now, this seems to be a bit strange, but it's not so strange, because for the West Indies, English law is something that is well known. And for the Turkish legal system, Swiss law is not foreign, because at least the obligation part of the civil code in Turkey was based on the Swiss civil code. So there was a reason why those legal systems were chosen. But what happened was that the arbitral tribunal found itself in a situation of impasse because each of the parties wanted to rely on its own choice of law clause. So one of the things that arbitrators do, they try to reach a solution. They try to help parties reaching a solution. And so this tribunal suggested to the parties to agree on the application of the UNIDROIT principles. You see, the UNIDROIT principles as a tool to reach a result when there is a dispute. So the parties actually agreed, and strangely enough, they said that in respect to the disputed issues, the UNIDROIT principles were found to basically correspond to both English and Swiss law, which is a bit strange because the two legal systems are very different, but it shows that each party could look at the UNIDROIT principles and find them reassuring, find them balanced, and therefore not threatening, even if they are not completely the same as their own domestic law. So they could agree on that. And these are the provisions that were cited, the general article on good faith in the practical application of the duty of confidentiality, one rule on the interpretation, the fact that the contract has to be interpreted to the disadvantage of the party that has drafted it, the clause or the contract, if one of the parties had unilaterally drafted it, and then the rules on damages. So let's come to this slide because there is something that I would like to very quickly develop with you. So we have seen here that in the previous slide, we have seen that the arbitrator suggested to the parties to apply the UNIDROIT principles. So it implies that the UNIDROIT principles can be applied as the law of the contract in an arbitral setting. And this is actually something that is considered to be absolutely possible. We see here the ICC rules on arbitration, Article 21. The parties shall be free to agree upon the rules of law to be applied by the arbitral tribunal. And since the term rules of law is used, it is implied that even soft law instruments at international level can be used as the law of the contract. And the same, the model law on arbitration and the ancestral arbitration rules and many domestic law arbitration rules. But of course, there are also legal systems that have a different view when there is a court involved, when there is a domestic court involved. And in many cases around the world, not all, but in many cases, actually the court would not be able to consider the UNIDROIT principles as the law applicable to the contract. But the important thing to underline is that in this case, and we have case law on that, parties can refer to the UNIDROIT principles as the content of their contract. And since most of the rules of the UNIDROIT principles in domestic laws are not imperative, they are not mandatory, so parties can change them in their contract. The reference to the UNIDROIT principles is upheld. So in a way, this difference is not as big as one would think it could be. But from a doctrinal point of view, of course, it's quite important. And we can also see that the ACCH principles, our sister organization of 2015, went in the direction of allowing more freedom of choice to the parties, including the possibility to choose rules of law, even if there is a domestic court involved, but unless the law of the forum provides otherwise. So it's a kind of hint to legislators to change the law. And it did happen, for example, in Paraguay and in Uruguay very recently, but of course, this is something that is not accepted in all jurisdictions. The important thing about the HCCH principles from our perspective is that the UNIDROIT principles are expressly referred as the typical example of the type of rules of law that would be accepted by the HCCH principles, because it's generally accepted on an international level as a neutral and balanced set of rules. Now, I have come now to another case I wanted to have a look at. Sorry, I have to go back to this. Okay, so until now, we have seen the application of the UNIDROIT principles in arbitration. We have seen the application of the UNIDROIT principles as the governing law of the contract. Now, I would like to have a look at a completely different way to use the UNIDROIT principles, which is the UNIDROIT principles as a tool for domestic law judges in order to interpret their own domestic law, which is the applicable law in that particular case. Now, this seems to be a bit strange because the UNIDROIT principles are really tailored to international commercial contracts, and those disputes are many times they are domestic in nature, and they also involve contracts that are not necessarily international. So why is this the case? Because the UNIDROIT principles became well known in academia and in other circles, and they became as a possible reference in order to help the development of domestic laws in certain sectors. So if the domestic law is completely clear on a point, the UNIDROIT principles will hardly be referred to. Maybe they will be referred to just to say that that domestic law is up to the developments at international level. But there are certain cases where domestic law is evolving, and legislators have not really introduced a new law, but of course we have judges with maybe conflicting decisions, and some of the interpretations are more suited to modern developments of international contract law than other interpretations which are more traditional. And so the UNIDROIT principles have been used in many situations by judges from very different backgrounds, from civil law to common law, in order to give more strength to the interpretation that goes in the direction of modernizing contract law in general, not only international contract. We have examples from decisions in many different jurisdictions on interpretation of the contract, on remedies, on formation of the contract. I have chosen one example just because of the fact that it is a common law jurisdiction, and sometimes common law jurisdictions are said not to like the UNIDROIT principles because they are too civil law oriented. But this is actually not true, because as we have seen, they are a balanced set of practice-oriented rules. So of course, civil law systems can find a lot of rules that are in their own legal system and civil laws, but also common law judges have found useful to refer to the UNIDROIT principles. And this is a case in Australia. It's a bidding procedure. There was a foreign company bidding for a contract with an Australian governmental agency. There was a negotiation, and but then the foreign company, the claimant, claimed that the defendant had failed to conduct the tender evaluation fairly and did not give an equal opportunity to all bidders, because then the contract, after all these negotiations, was given to another bidder. Now, what was the law that had to be applied by the Federal Court of Australia? It was actually in evolution, in the sense that we know that the traditional English law would not be keen on awarding damages in this situation, except in certain circumstances. We know that other legal systems, like in the US state law, they have developed different rules. Here, the Australian judicial and scholarship opinion differed sharply on this matter. So they decided to rely on the UNIDROIT principles in order to affirm the decision that actually in the special situation, the duty of good faith had been breached, and that was a sufficient ground to award damages to the foreign company. And we see that the company is not even the domestic one, it's the foreign one. So it's really a move to change the law in the direction of international developments. So I thought that this was a good example, even if the decision is a bit old, but because it shows the way that that a judge can use the UNIDROIT principles in order to advance a specific interpretation of the domestic law. We have also other cases, for example, giving more strength to a general principle that it's not necessarily expressed in a legal system. For example, the principles of not going against an action that one has done, venire contra factum proprium, and others. So in this respect, this is one of the areas where the UNIDROIT principles have really been particularly useful in the development of the law. Now, I only have another couple of slides. This is the last one on the further projects based on the UNIDROIT principles. I thought you might be interested in knowing what is happening. So we are at the moment not working on a specific new edition of the UNIDROIT principles. The 2016 is the latest, but we have used the UNIDROIT principles as general contract law to develop our projects in other areas for special contracts. For example, all the UNIDROIT work on contracts for the agricultural production and land investment, so the UNIDROIT FAO IFAD legal guide on contract farming, and also the agricultural land investment contract legal guide with IFAD of 2020, a newborn instrument, they're all based on the general principles of contract law of the UNIDROIT principles with the adaptations that are needed for these sectors. And we also have a project on reinsurance contracts, which are extremely important from a practical point of view, and also from an economic point of view. In this project, UNIDROIT was involved to give information on the UNIDROIT principles, and one part of this project has already been published in 2019. And the work is going on. And these principles of reinsurance contracts refer to the UNIDROIT principles as the general rules of contract with adaptations. So this is just to say that we have this role of the principles as a kind of background law for further activities. So I think I can stop maybe here. I hope I have not overdone my time. This is the entrance of our beautiful institute in Rome. We hope that you will be able to visit us and to come. We have a program for interns and for scholars that might interest you, the students. I'm particularly talking to students or advanced students, because we take usually PhD graduates or people writing their PhD. So please take also this into account in visiting our website, which is here. Thank you very much, and I am at your disposal should you have any questions or comments on what I have said. And I'll stop the, here we are.
Yes.
Okay.
Yeah. Thank you very much, Professor Anna, for very insightful and comprehensive lecture about the UNIDROIT principles of the international commercial contract. And I believe it's not about the principles only, but we have so many new informations about what UNIDROIT done with the new conventions, as well as with numbers of the hard law and soft law that UNIDROIT have. we found numbers of the keyword on how the implementations of the principles in numbers of the systems, civil law, both common law. And I think it's really interesting for the student to look further about how the principles implement in numbers of the countries, include Indonesia maybe. And it's really interesting to understand about the hardship principles. It's really relevant for today's numbers of the discussions on the implementations of the contract because of the pandemic, COVID-19. And I think numbers of the participants here has already put numbers of the questions and will directly or maybe could discuss in the discussion sessions. I think numbers of the student also learns a new conventions or new law done by the UNIDROIT, and maybe could inspire them to have further research as the final exercise, since I think the final exercise also could submit to the publish in the national or international journal, so we can contribute in terms on how Indonesia could contribute for the UNIDROIT law. And maybe what I have in my mind when we learn about how the state implement the principles is to what extent, if there are some cases, or to what extent that the court in Indonesia could implement, or to what extent that the court has implement the principles of the international commercial contract. It would be interesting to learn. And I think all the students is really relevant to understand further each or every articles on the UNIDROIT. There's 11 chapter with the 11 articles with numbers of the principles. And I think it would be really interesting to exercise in numbers of the legal aspect. Thank you so much, Professor Anna. And we wish you, I think I have a dream to come in a UNIDROIT institute and to have a research if my dean give the permission to to have a research in the UNIDROIT. Thank you very much. And now we move to Professor Hamza Hameed, would be deliver a lecture about the Cape Town Convention. As an information that Indonesia also ratified these conventions by the President Regulation number 8 on year 2007. And there's numbers of the topics on the implementation of the Cape Town Convention, especially for the aircraft protocol in the COVID-19 as well. And I think without further ado, we would like to welcome Professor Hamza Hameed for the lecture. Your time and the screen is yours.
Thank you very much, Professor Prita, and my sincere thanks to everyone for organizing this very kind. Thank the dean for. Can you still hear me?
Yes. Maybe a little bit some technical or about the connections, but now is better.
Okay, well, yes. So thank you very much to the kind dean for the introduction, Ms. Prita, my friend Taufik. We're very grateful at UNIDROIT for being here today on this online lecture at the Universitas Padjadjaran, and I'm particularly pleased to talk to all of you today about one of UNIDROIT's instruments, which is the Cape Town Convention and its various protocols. So I will I'm sorry, every time I try to share my screen, my Zoom turns off. Let me try one more time.
Yes, I think there's some technical issue or connection issue if you share the slide.
Yes, okay, so.
But maybe you can leave them like this and go on.
Does it work now?
Yes.
Okay.
We could try.
Right. So sorry for that. So like I was saying, I'm very pleased to talk to all of you about the Cape Town Convention and its various protocols. Of course, Anna had the easy task of introducing one instrument. I have the task of introducing 4 treaties in 45 minutes. So unfortunately, the presentation will have to be slightly general. But like I noted, would be very happy to welcome questions at the end. So if it's okay, then I'll start by showing all the students this video, which very well introduces the Cape Town Convention, and then I'll lead into my presentation. So I'll play this now, and hopefully all of you should be able to hear it.
The Convention on International Interests in Mobile Equipment is one of the most successful international commercial law treaties in history. Commonly known as the Cape Town Convention, the treaty was developed by the International Institute for the Unification of Private Law, or UNIDROIT. Adopted in Cape Town, South Africa in 2001, the convention has been ratified by over 80 countries to date.
Here at UNIDROIT, we are extremely proud of the Cape Town Convention. Notwithstanding the fact that it has only recently left its teens, it is already one of the most widely adopted commercial treaties in the world. The Cape Town Convention provides legal and economic benefits for both developing countries and fully developed economies. This is demonstrated by the treaties having been adopted by countries from all over the world in its different regions and legal traditions.
The Cape Town Convention has successfully established an international legal regime for the creation, enforcement, registration, and priority of security interests in certain categories of high-value, uniquely identifiable mobile equipment. The convention is applied to different sectors through individual protocols. The 4 existing protocols to the Cape Town Convention are the Aircraft Protocol, adopted in 2001, the Luxembourg Rail Protocol, adopted in 2007, the Space Protocol, adopted in 2012, and the Mining, Agriculture, and Construction Protocol, adopted in 2019. Where a debtor is located in a country that has adopted the convention and relevant protocol, security interests, title reservation agreements, and leases in equipment can be registered in an online international registry. Once registered, these international interests have priority over other interests in the case of the debtor's default or insolvency. Even when the asset moves across international borders, the international interest remains effective.
The Cape Town Convention has established a strong legal regime with enforceable legal rights. As a result, the Convention allows financiers to provide credit in countries where they were previously unable to do so. In other countries, the Convention lowers the cost of credit. By enhancing legal rights, increasing the availability of credit, and lowering the cost of credit, the Cape Town Convention benefits both debtors and creditors. Through its protocols, the Convention assists many different sectors in society.
Under the Convention, companies in the aviation, rail, space, mining, agriculture, and construction sectors can acquire new equipment, thereby increasing productivity and profitability and decreasing operating costs and risks. Manufacturers benefit from higher demand for their equipment and increased output. Dealers and traders can export and import an increased volume of equipment. Financiers benefit from greater legal protection in issuing credit, allowing them to provide cheaper financing in existing markets and expand operations to new markets. The Cape Town Convention has economic benefits for countries that adopt the treaty and its protocols. The Aircraft Protocol entered into force alongside the convention in 2006. Since then, there have been over 1 million registrations recorded in its international registry against more than 250,000 aircraft objects, with an estimated value of collateral of over $500 billion. The Rail Protocol is predicted to have significant benefits for different regions in the world. A recent study suggests that the Rail Protocol will provide direct microeconomic benefits for European Union countries of over 19 billion euros. In Africa, the Rail Protocol is expected to provide microeconomic benefits of up to 13.5% of the present value of all rolling stock. The Space Protocol will be important in increasing access to credit for the new space sector. As the industry expands further and access to space becomes more affordable, the Space Protocol will be particularly important for companies in developing countries that currently face limitations in the availability of credit. The MAC Protocol is predicted to have a positive impact of $23 billion on the GDP in developing countries and of $7 billion in developed countries, for a total impact on GDP equivalent to $30 billion a year. It is estimated that over a 10-year period, the protocol may increase the amount of MAC equipment in developing countries by $90 billion. To take full advantage of the benefits of the Cape Town Convention, UNIDROIT encourages all countries to consider adopting the Convention and its 4 protocols. UNIDROIT is the depositary for the Convention and protocols and can assist countries that are considering adopting the treaties. Further information on the Cape Town Convention and its protocols is available on the UNIDROIT website.
So that was a very quick introduction to the Cape Town Convention and a lot of the things that I will talk about. As noted in the video, the Cape Town Convention is one of the most successful international commercial law treaties in the world. On this slide right over here, you can see the status map of the Cape Town Convention, which showcases that currently there are 83 states that have become contracting states to the Cape Town Convention. This, of course, includes Indonesia, as was mentioned earlier, but it also includes states from all parts of the world. And so the impact of the Cape Town Convention is truly felt in all jurisdictions. So what is the Cape Town Convention and why was the Cape Town Convention introduced? As a starting point, there was in the late 90s and around that time, a large growing global need for financing, including private capital in the acquisition of high value, mobile, and also uniquely identifiable equipment. This was particularly evident in the aviation sector, where a large amount of airlines were becoming privatized, and there was exponential growth in the air traffic industry and the aviation sector. There was also a large reduction in public capital and a need for airlines and operators to attract private means of financing. And there were also lots of positive externalities of buying new airplanes, such as greater safety, better environmental standards, etc. And so at the same time, there were lots of legal obstacles in the use of asset financing and leasing, particularly when conducting cross-border transactions where debtors were often based in countries where there was a lot of legal uncertainty and there were no clear laws relating to what happens in the case of an insolvency. Traditional conflicts of law approaches were more often than not suitable for moving assets, and legal systems varied in their approach towards the recognition of security interests and the process of enforcement for, in the case of an insolvency, and the remedies available to creditors in that regard. So the solution, UNIDROIT, along with its expert working groups and partner organizations, came up with a uniform legal regime created by treaty, which facilitates the financing and leasing of certain types of uniquely identifiable, mobile, and high-value equipment used in certain sectors. in the beginning, alongside the Cape Town Convention, UNIDROIT, in partnership with the International Civil Aviation Organization, or ICAO, finalized the aircraft protocol, which was applicable to the aviation industry. Thereafter, the rail protocol was finalized in 2007. The space protocol was finalized in 2012, and the mining, agriculture, and construction protocol was finalized in 2019. And I'll talk about all of these in the next few slides. The Cape Town Convention treaty system is very unique in international law, whereby it adopts an umbrella structure where there is a head convention, which is the Cape Town Convention itself. And then the application of the convention is extended to specific industries, but through the adoption of specific protocols. So as I mentioned already, there are presently 4 protocols to the Cape Town Convention, and they relate to 4 distinct industries. And for them to apply, a country has to ratify or become party to a particular protocol and the convention. So in the case of Indonesia, for example, as was mentioned earlier, Indonesia is a contracting state to the Cape Town Convention and its aircraft protocol, which means that those 2 instruments apply, but not yet, at least, a party to the rail protocol or the space or MAC protocols. And so at the present time, those provisions would not apply domestically in Indonesia. This two-tier structure has several advantages, such that it allows for building in flexibility into the different into the different protocols. It allows for different protocols to be tailored according to the needs of the particular industry. And as such, all of the different protocols have certain specific articles that are very much only applicable to that specific industry, thereby allowing industry participants to enter into transactions that are well regulated according to the needs of the sector. Some of the basic benefits of the Cape Town Convention are that the Cape Town Convention and its protocols aim at increasing certainty and reducing risks in asset-based financing for certain types of uniquely identifiable high-value mobile equipment. How it does this is through the application of an international system of secured transactions law to the various assets that it applies to. So, for example, what the Cape Town Convention does is that it allows for parties to create international interests over equipment, which can take the form of a security agreement, a conditional sale, or a lease agreement, or a title reservation agreement. These international interests within assets can then be registered in an international registry. These are dedicated, wholly electronic international registries that are established under each protocol of the convention. These registries ensure a high degree of transparency and predictability, as well as effectiveness. And we'll dig into the registry a little more later. The convention provides a very clear set of priority rules, which by means of registration in the registry, there is a clear rule for determining who has priority or which creditor has priority in a particular asset. These priority rules include rules for priority against competing international interests, but also against domestic law interests with a specific number of well-defined exceptions. The convention has provisions for effective enforcement and measures that are also applicable in insolvency. The Cape Town Convention provides for swift and effective enforcement measures, including out-of-court remedies, if agreed so by the contracting states, that allow for things such as advance relief pending final determination. This ensures that the value of the asset under question can be restored and preserved in the case of an insolvency, and that creditors can easily recover the cost of their investments if and when there are issues in continuing to receive the payments for that particular asset. The Cape Town Convention and its various protocols allow for flexibility to be achieved through declarations, which means that states, when implementing a particular protocol of the Cape Town Convention and in the convention itself, can make certain policy choices that have significant impact on the application of the protocol within their domestic jurisdiction. These declarations can include the choice of insolvency provisions or even the types of unregistered interests that may sometimes need to be paid off before a registered international interest can be enforced. And these protocols offer enhanced creditor protection, thereby allowing states to have stronger creditor rights in place and allow greater confidence for creditors when deciding to invest capital into another state. So the system of priority that I talked about works in the same manner almost across all the protocols of the Cape Town Convention. And that's why I thought it'd be good to showcase this slide before digging into each one of the protocols individually. This slide illustrates the system that exists, whereby wherever there is an asset within the scope of a particular protocol of the Cape Town Convention, an international interest can be created in that asset in the form of a security agreement, a title reservation agreement, or a leasing agreement. This international interest can then be registered and then protected through registration in an international registry. Once this registration has been done, the rights of that creditor or the interest of that creditor in that asset takes priority over all other subsequently registered interests in the international registry, as well as unregistered international interests and domestic law interests. It's important to keep in mind that this priority applies even if the domestic law interest was registered prior to the international law interest, and constructive knowledge of another domestic law interest is irrelevant in order to ensure the priority of an international law interest. So what are some of the protocols of the Cape Town Convention? The first protocol, and which is also the most successful protocol of the Cape Town Convention, relates to the aviation industry. This is the aircraft protocol, which was negotiated alongside the Cape Town Convention in 2001. This has 80 contracting states, and as was mentioned in the video, there are more than 1 million registrations in the aircraft protocol registry. I was just informed 3 days ago that this number is now actually over 1.3 million registrations rather than just 1 million. The estimated value of collateral in the aircraft protocol registry is now greater than $650 billion US. And the aircraft protocol has delivered quantifiable benefits to aircraft financing, whereby the OECD has created a provision for a Cape Town discount, which allows public sector lending agencies such as export-import banks to discount the cost of financing to up to 10% when lending to operators based in states that have signed and ratified the Cape Town Convention and made certain relevant declarations. The Cape Town Convention's aircraft protocol has improved ratings in recourse to capital market and debt financing, and has created better conditions for commercial credit, including leasing operations. The second protocol of the Cape Town Convention is the Luxembourg Rail Protocol. This is a particularly important protocol as in the rail sector, there are only a few legal systems that have functioning domestic legal framework securing creditors using railway rolling stock as collateral. The Rail Protocol facilitates cross-border acquisition and use of railway rolling stock equipment. It fosters operating and finance leases in this sector, which used to be very uncommon in the past, with financial and economic benefits for states and private sectors alike. The International Registry for the Rail Protocol has the capacity to and will establish a new global system of equipment identification, which is again something that's not currently present in the rail industry. And the protocol will foster sustainable development and environmental friendly development through the use of railway rolling stock for transportation of people and freight. And as most of you already probably know, rail transportation is considered much greener than various other forms of transportation, including road and aviation. So the Rail Protocol of the Cape Town Convention applies to various different types of railway rolling stock. It's not only the traditional high-speed trains that you think of when you think of the rail sector. In fact, the Rail Protocol applies to freight trains, interurban rolling stock such as metros and light rails and trams, and even people movers such as those found in airports and cranes and cable cars. So the scope of the Rail Protocol is indeed quite broad, and it tries to bring some of the similar benefits that have already been experienced in the aviation sector to the rail sector by means of creating an international system of secure transactions law that will bring down the costs of credit and allow for more private sector capital to flow into the rail industry. In terms of where the Rail Protocol stands right now, while it has not yet entered into force, the requirements for the Rail Protocol to enter into force are that it needs 4 contracting states, and it also needs a certification by the supervisory authority that the registry is working. At present, we have 3 contracting states, which are Luxembourg, Gabon, and Sweden. But at the same time, we also have a number of other states that are considering or working on the process of ratification. In fact, just yesterday at the UNIDROIT headquarters, the Kingdom of Spain signed the Rail Protocol at a signing ceremony, and that makes them one of 7 other signatories to the Rail Protocol. The European Union has also approved the Rail Protocol, allowing for various European countries to sign and eventually become contracting states. So once the Rail Protocol enters into force, here at UNIDROIT, we are very positive that economic benefits from the Rail Protocol will start to flow in. There have been various economic studies that have been conducted for the Rail Protocol, all of which have shown significant economic benefits, both in terms of the reduction of costs of acquiring new railway rolling stock and the benefits experienced by people in terms of better rail transportation and in freight transportation. The third protocol of the Cape Town Convention is the Space Protocol, which was negotiated and finalized in 2012. And if it's okay, then I will show you guys a another very quick short video that also introduces the Space Protocol.
The Protocol to the Convention on International Interests in Mobile Equipment on Matters Specific to Space Assets, better known as the Space Protocol to the Cape Town Convention, is an international treaty adopted in Berlin in 2012 which facilitates the use of asset-based secured financing for the space sector. Developed and negotiated under the auspices of the International Institute for the Unification of Private Law, or UNPAD-UNIDROIT, the Space Protocol is part of the Cape Town Convention system, which also includes protocols for the aviation, rail, mining, agriculture, and construction sectors. The Space Protocol allows for the creation, registration, and enforcement of international interests in space assets, which can either take the form of a security agreement, a title reservation agreement, or a leasing agreement. As the space sector continues to grow and more emerging countries and companies from different parts of the world start to get involved, access to credit and availability of finance at reasonable terms will be key in order to allow businesses to develop and space economies to expand. The Space Protocol allows private investors to lend across borders with certainty and confidence that should anything go wrong, their rights and interests in their space assets will be upheld in a court of law, as long as the debtor is based in the contracting state of the protocol. The Cape Town Convention and its aircraft protocol have been described as some of the most commercially beneficial treaties ever adopted. The convention presently has more than 80 contracting states from all parts of the world. The Space Protocol adapts the provisions of the convention to the specific needs of the space sector. The Space Protocol scope covers all types of space assets in space or designed to be in space, and includes objects such as satellites, transponders, reusable launch vehicles, rovers, space infrastructure, and others. Once a creditor and a debtor enter into a security agreement, a title reservation agreement, or leasing agreement, the creditor can register its interests in the space asset into an international wholly electronic registry. Once registered, this international interest has priority over subsequently registered interests, domestic law interests, as well as unregistered rights and interests in the case that the debtor becomes insolvent. The Space Protocol has specific provisions that cater to the special characteristics of the space market and the assets involved. Thus, it provides for creditors remedies that take the in situ nature of space assets into account. For example, by providing for the use of mechanisms such as the transfer of tracking, telemetry, and control information of a space asset, or the assignment of debtors' rights. Additionally, the Space Protocol also has specific provisions for other space-specific issues, such as physically connected space assets, salvage for insurers, and space assets which serve a public service. Insolvencies of space companies result in the creation of space debris. Not only will the Space Protocol allow for access to space to a larger number of private companies from all parts of the world, it will also provide for sustainable space exploration through providing an efficient mechanism for the in situ transfer of space assets to new operators. The space sector is no longer the realm of a handful of operators providing a limited number of services. It is now the domain of smaller, leaner, more innovative businesses which make up the new space industry. Studies predict that the size of the global space sector to be as large as 1.1 trillion by 2040, with thousands of assets being sent to space every year. The Space Protocol is perfectly suited to serve as a tool to facilitate this growth and allow more capital to flow into space businesses of all natures and sizes. UNIDROIT and its partners are continuing to promote the Space Protocol to establish the international infrastructure required for its entry into force. We are also actively engaged with governments and policymakers looking to provide their space industries with an additional channel through which they can finance their space ventures. Please contact the UNIDROIT Secretariat for any further inquiries about the Cape Town Convention or its protocols.
So that was a quick video introducing the Space Protocol. As was noted in earlier parts of my presentation and in the videos, what the Cape Town Convention and its protocols do is that they really do reduce the costs associated with getting finance for debtors and businesses that are looking to finance particular assets. So when you think of a financing transaction, you think of a bank or a financier and you think of a debtor, this bank or financier thinks of three main factors when lending money to anybody. It's particularly when lending money on an asset-based model. The first of these is the amount of the loan or financing that's being granted. The second is the value of collateral, which can be recovered, net any costs of recovery. And the third is the degree of certainty over loan payments. So what the protocols of the Cape Town Convention do is that they really significantly impact that second prong, which relates to the value of collateral, which can be recovered at any cost of recovery, because they make the costs of recovery much lesser, and in the process of recovery much easier. As such, as was noted, the space protocol, by creating a uniform regulatory regime for the recognition and protection of security interests in assets, can allow operators to leverage their assets and attain finance by giving creditors rights in those assets. The space protocol allows for companies in the space sector to obtain financing based entirely on their business models rather than having to sell parts of their companies. And they allow companies to leverage their technologies and their assets to use them as collateral in order to obtain credit. I will skip over these in the interest of time, but as noted, the space protocol has certain specific elements that are particularly designed for the space industry. These include the introduction of a very unique repossession mechanism, which allows for operational control over a satellite to be transferred to a new operator if and when a satellite operator goes bankrupt. So this allows for a creditor to take back control of the asset and then hand it on to a new operator, thereby regaining or at least rescuing some parts of their investment. The space protocol also has clauses on all of these other things that you can see on the screen. And if anyone has any questions on them, then I'd be very happy to dig into them further. In terms of the status of the space protocol, it's also being heavily promoted by UNIDROIT right now. And as the space industry continues to grow, we are finding many more states to be very interested in this treaty, and states that are trying to look at it as an option to inject more private sector capital into their space markets. Finally, the Mining, Agriculture, and Construction Protocol of the Cape Town Convention, or the MAC Protocol. This is the most recent addition to the Cape Town Convention system and was adopted in 2019 at a diplomatic conference in South Africa, which was attended by over 150 delegates from 43 different states. That included a very strong delegation from Indonesia, who we were very happy to host and meet. The mining, agriculture, and construction sectors are huge. They make up large parts of the economies of many developing countries and also developed countries. But at the same time, there is a big unwillingness from financial institutions to lend or lease equipment in the mining, agriculture, and construction sectors due to uncertainty created by domestic laws, particularly with the possible movement of assets across borders or the challenges of enforcing rights in these assets upon insolvency. And credit at the present moment covers as little as 20% of the product value in developing country markets. And these are some of the challenges that the MAC protocol seeks to address. By creating this international system of secure transactions law, the MAC protocol will allow more private sector financing to flow between different countries into the MAC sectors. And an independent economic assessment that was conducted for the MAC protocol predicts that the MAC protocol will have a positive impact of $23 billion on the GDP of developing countries and a positive impact of $7 billion on the GDP of developed countries, for a total impact of $30 billion USD per year. At the same time, it's also predicted that the MAC protocol has the capacity to increase the total stock of MAC equipment by $90 billion over a 10-year period. This economic assessment was limited to only the 63 member states of UNIDROIT, so the actual impact of the MAC protocol is predicted to be much larger. The MAC protocol has benefits for the private sector, ranging from farmers, agricultural entities, to builders, to mining entities, to manufacturers, to dealers, to financiers, everyone that's involved in these sectors, by means of reducing the cost of credit, allowing for more newer equipment to flow into the mining, agriculture, and construction sectors, and allowing for greater certainty for financiers when extending credit. The table at the bottom highlights the amount of mining, agriculture, and construction equipment that falls within the scope of the MAC protocol that is presently being imported and exported from Indonesia. As you can see, in 2018, Indonesia imported over $3.7 billion worth of MAC equipment and also exported $440 million worth of equipment. As such, if Indonesia were to become a contracting state of the MAC protocol, it would really benefit from cheaper access to credit and thereby allowing Indonesian farmers, agriculture people, construction companies, and mining companies to import more equipment at a lower cost, while at the same time, it would allow exporters of MAC equipment in Indonesia to find a bigger market. The MAC protocol presently has 5 signatory states, including the United States of America, which signed the MAC protocol last year at a signing ceremony in Rome. And at present, UNIDROIT is continuing to build the international infrastructure necessary for the MAC protocol to enter into force. Finally, my last 2 slides, I would, as a majority of the participants of this call are students, I would draw your attention to the Cape Town Convention academic project. This academic project contains a comprehensive, digitized, and searchable repository of everything to do with the Cape Town Convention, including official texts, including legislative material, case law material, academic articles, and all of the documents that led to the development and negotiation of all the treaties within the Cape Town Convention system. Additionally, on this website, students can also get free access to the official commentary of the Cape Town Convention and all of its protocols. This free access is only for academic purposes and only available to students. So I would highly recommend, if you're interested in doing research into the Cape Town Convention, to check that out. You can also find a lot of additional information about the conference that we organize every year on the Cape Town Convention and in the Cape Town Convention academic journal. And finally, as my Deputy Secretary General already mentioned, UNIDROIT has a very comprehensive internship and research scholarship program that allows students and young professionals to come to Rome and undertake their research with us. Unfortunately, the application process for the 2022 cycle has already finished, but we do these recruitments every year. So please keep an eye out on the UNIDROIT website and our social media channels for the next call for applications, which will be posted around summertime next year for our 2023 cycles. And with that, I'll conclude, and then hopefully we have some time for questions, but if not, then please do email me or my colleague, and we'd be very happy to address any questions that anybody has. Thank you.
Thank you, Mr. Hamza, for the lecture. It's really interesting to learn a lot about the Cape Town Conventions. I do agree that the Cape Town Conventions is a unique conventions. It's not only for the public international law, but also for the private international law. The Cape Town Convention is give the new development, especially for the mobile equipment in the private international, include in Indonesia. Prof. Anna and Prof. Hamza, since Indonesia is still using the law very conventional regulations on the mobile equipment, and currently we have to adjust with the new concept of the mobile equipment, starting with the aircraft protocol. And I think all the student could get the new inspiration to have a research on the Cape Town Conventions, especially for the space asset or the railway stock or the mining, agriculture and construction equipment. It's really relevant with the Indonesia. And I think since the time that we have is limited, and I think Prof. Anna and Prof. Hamza has a number of activities after this event. I think we could directly move to the discussion session by invite participants to join with these discussion sessions. And I think we have already we have 2 questions in the chat box. If I may read for you, Prof. Anna and Professor Hamza, we have a questions from Quinasa. Quinasa is one of the students from the Transnational Business Law Department. And the first questions is in the civil code, the basis law of contract in Indonesia does not recognize hardship because it's only written about force majeure. And I read an article that stated in the US doctrines about hardship is no longer admitted. What is the actual positions of the regulations regarding hardship? Can it be applied in domestic contract or only in the international contract? And maybe we can also mention the second questions, and Prof. Anna could answer the question together. Also, why the hardship clause is usually written in the force majeure setting, even though the implications are different. And I think, Prof. Anna, if I may add some context in the implementations of the leasing agreement in the aircraft, we understand that the COVID also give very complex issue for the implementations of the leasing agreement. Maybe Prof. Hamza also could add after Prof. Anna. Thus, hardship is relevant to be implemented in this COVID situations, since we understand that the force majeure clause could be found in the leasing agreement as well. But then how we could give the solution for the implementation of this contract. I think that's for the first session, Prof. Anna, before we move for the another question.
Thank you very much, Prita, and thank you very much for the 2 questions, which are extremely relevant and to the point. Just 1 second, that I think you cannot hear me well. I hope you can hear me better now.
Yes.
Okay. First question. If I understand well, but please correct me if I'm wrong. I understand that the Indonesian civil code had originally taken as a model the old Dutch civil code, at least for some aspects, and in that civil code in itself was heavily influenced by the French civil code of the time, which meant, as very rightly written in the question, that the only doctrine recognized was the one of the force majeure, and that hardship was not recognized. On the opposite, the French system was very rigid against it, except for the relationship with administrative authorities, where it was accepted. So what happened in the meantime, as you may know, civil codes were actually modernized and adjourned. And the UNIDROIT principles played a role, especially for the French civil code, but also the discussion on the UNIDROIT principles that were developed at the time played a role also for the Dutch civil code. And so the new Dutch civil, not so new now, of 92 does recognize a doctrine that it's very, of change of circumstances, that it's very similar to the hardship. And so it also allows even for the intervention of the judge to reestablish the equilibrium, while the new French civil code really changes the traditional approach of French law, following up on a string of decisions which had reached a similar conclusion by applying general principles of solidarity and of also good faith. And so it does recognize the right to renegotiate the contract in the very special situations of hardship, and then also the possibility of the judge's intervention. But all this to say that legal systems are now little by little recognizing the usefulness of a doctrine such as the hardship. At the same time, there is a reference to the US. And here I think it really depends on what we are talking about. because the recent pandemics has created a number of very exceptional situations, and there might have been also responses that were ad hoc responses in order not to disrupt the whole market. And but it is true that the hardship may play a different role depending on the type of contract. And also depending on what the parties have written in their contract. So if we look, for example, at the lease agreement, what I can suggest is that, as it happens very often in practice, the lease agreement, if it has a commercial nature, will contain a clause that the UNIDROIT principles will recognize, because the UNIDROIT principles are derogable in their provisions, except for the general good faith principle, which would not necessarily apply in this case. So, so we do recognize the fact that the party autonomy can insert in the contract a tighter regulation that does not recognize supervening circumstances, or only recognizes some supervening circumstances. The second question, and I will be shorter on that, I understand that the second question really deals with the clause in itself and not the general regulations in the civil code of hardship and civil and force majeure. And in this case, I would say that it is correct. For example, the ICC puts the two clauses one near to the other, and has developed a force majeure clause that even contains some consequences that are similar to the hardship, because it also allows for example, a remodulation or renegotiation of the contract. So it is true that in practice, there might be a kind of blurring of the two situations. The UNIDROIT principles distinguish them very clearly, but they do make a link, and they say the difference is the effects of as the question says. So the situation might be the same in certain exceptional circumstances, but the effects then will be different, and therefore parties in those exceptional situations may choose which one to use if those rules apply and the clauses do not say something different. So sorry if I took too much time, but the questions were very large, and I probably did not answer all of them, but I hope I have given at least an initial answer, food for thought.
Thank you for respond, Prof. Anna. Yes, it's really interesting questions, and we could write an essay to give the responses. It's really interesting. Thank you very much. And maybe Prof. Hamza, maybe you have something to respond, maybe related to the implementations of the leasing agreement as well.
No, I wouldn't have anything to add to that. Anna is certainly the expert in this area, but I see that there's a Cape Town Convention question by Amy in the chat.
Yeah, you can, yes, respond. Yeah.
Right. So Amy, thanks a lot for that question with regard to what happens if there is some sort of a discrepancy between the convention and the protocol and the relevant domestic law. So unfortunately, this happens quite often. Of course, the Cape Town Convention and its aircraft protocol are international treaties. And when a country signs on to an international treaty, it's sort of obliged to pass, if it needs to, then it has to pass implementing laws domestically to make sure that all the provisions of the treaty start to apply to the industry participants within that jurisdiction. And sometimes what happens is that implementing legislation is not entirely in line with the subject or the object of the treaty. And what this unfortunately ends up or has the capacity to do is that the benefits that the treaty brings don't sometimes pass on to that jurisdiction. So for example, if in a jurisdiction the clauses relating to remedies available to creditors in the case of an insolvency under the aircraft protocol are not implemented the way that they're supposed to, then then operators within that jurisdiction might not be eligible for the financing discounts that other operators would get in different parts of the world. And yes, so that's why the Cape Town Convention, while it does have a series of declarations that states can make when signing on, the declarations that a state makes are very important insofar as whether or not the economic benefits of the treaty pass on to that jurisdiction. So I think the situation that you're mentioning came up very often recently, particularly with the COVID-19 pandemic, where several states passed legislation, emergency legislation that put restrictions on repossession of things such as aircraft, and also put restrictions on bankruptcies and insolvencies of companies, noting the global health crisis that was going on. And so in some cases, there were circumstances where this was in contradiction to the state's obligation under the Cape Town Convention. And in many of these cases were litigated. I would point you to the Virgin Australia proceedings, which have recently had a judgment passed for a very good sort of understanding of some of these issues. But then there have been proceedings in different parts of the world where the Cape Town Convention has come out as the primary law applicable to these types of issues, where an airline has gone insolvent even in the middle of a pandemic, and the creditor wanted to exercise the remedies available to it. But at the same time, you have to also recognize that particularly in the pandemic, there were many creditors that were very willing to not exercise those remedies, as it was sometimes very hard to find another buyer for that airplane. And so because the Cape Town Convention and its aircraft protocol and all its other protocols provide for a great deal of party autonomy and for parties to be able to construct their contracts as they want to, this has really helped parties to, renegotiate the terms of their agreements and renegotiate their deals and continue in those financing transactions, while at the same time continuing to get the guarantees that have been provided by the convention. But of course, ultimately, international law is supposed to take precedent over domestic law, as a state's obligations under international law do rank higher. So I hope that answers the question, but there's lots of academic material that you can find on these subjects. And I wonder if Anna has anything to add to that. Thank you.
Yeah. Yes, thank you, Prof. Hamza, for the response. So if I may give you an information, Prof. Anna and Mr. Hamza, in terms of the implementations of the Cape Town Conventions, Indonesia has ratified by the government, by the presidential regulation, but then we also included into the aviation law number 1 on 2009. However, currently Indonesia has new law. We call it as a omnibus law to support the investment. And there's some interesting issue related to the aviation. So from this omnibus law, we have the government regulation number 32 on 2021, and there is some ministerial regulations. And there's some different, I think it's a part of the drafting issue. On the law number 1 on 2009, the substance is in line with the commitment or the obligations of Indonesia as one of the member states of the Cape Town Conventions. However, in the omnibus law, we were not change the substance, but then in the ministerial regulation, there's something different with the law number 1 on 2009, which is relate or in line with the Cape Town Conventions. But I think the government has changed the ministerial regulation now, try to adjust with our commitment, our obligations under the Cape Town Conventions. since the purpose of the omnibus law also to support the investment in line with the purpose of the Cape Town Convention to support the financing, aircraft financing as one of the element of the investment. But it's really interesting. Ami is one of the lawyer in Indonesia, and her expertise in the aircraft financing to and include the Cape Town Conventions. And thank you, Prof. Hamza, for the response. I think I do agree with your response. And I think we could move to the next questions. Prof. Anna and Prof. Hamza, we have Alif here. I think this is one of the student from the UNPAD as well. Now, Alif tried to raise the questions in related with the implementation of UPICC and the CISG as one of the exercise. If I may read the questions for you. In the event that both parties have chosen a law to govern their contract from a state that has adopted UPICC as their domestic contract law, yet the state is also a contracting state to more specific law, such as CISG, that would be also applied to the contract. And for the purpose of the questions, let's say that the contract and the parties would have the sufficient element for the application of this more specific law. Which law would be prevail? Those governing the state contract. Prof. Anna, the screen is yours.
Thank you very much. Now, I think this question, sorry again, now you can hear me better. Yes. I think this question contains many different questions, and so I will try to answer them very quickly. So there is a first scenario. The first scenario is, we know that the UNIDROIT principles are a soft law instrument, so they are not ratified by the state, while the CSG is a treaty, and therefore it becomes part of the law of of the contracting state. So in the first scenario, we have the parties have not chosen the UNIDROIT principles in their contract as soft law, which applies to the contract. But the domestic law, the contract law, has been influenced by the UNIDROIT principles and has therefore used the UNIDROIT principles as their model. In that case, the relationship between that domestic law, which has been influenced by the UNIDROIT principles, and CSG is the normal relationship between domestic law and CSG, which means that CSG applies instead of domestic law when all the conditions for its application are met. So an international sales contract of a certain kind, I'm sorry, and also a commercial sale. So, but I think this question could hide a different question, which is what happens if the parties choose the UNIDROIT principles in a sales contract where the CSG would be applicable to that contract because of the applicable law, because the applicable law is the law of a contracting state, or because the private international law rules refer to the law of a contracting state. Now, in this case, actually, the UNIDROIT principles would prevail insofar as the CSG itself has mostly non-mandatory rules. So the CSG has no mandatory rules, and therefore, if the parties have used the UNIDROIT principles as content of their contract, clauses of their contract, then those UNIDROIT principles would prevail. If the two are applied by a judge, for example, and in particular the UNIDROIT principles in a different setting, then I would like to refer, if I may, Alif, which I don't know if Mr. Alif, I would like to refer to the newly adopted legal guide by UNCITRAL, HCCC, and UNIDROIT on the application of international instruments to contracts of sales, and particularly the CSG, the UNIDROIT principles, and the Hague principles for the choice of law. And there you will see many different situations where the instrument might clash and how this clash can be solved. So I hope that this is a first answer to this very complex question.
Yes, thank you, Prof. Anna. I think we often meet these situations in terms on how the implementations of the UNIDROIT principles, domestic law, and CISG, especially in Indonesia. CISG is still the convention, and we haven't ratified this convention. Would be different situations again to respond. Thank you, Prof. Anna. I think. Prof. Hamza, do you have something to add, maybe? Okay. I think we have third questions. This is Irsad. Irsad is a transnational business law student as well. To make it clear, maybe these questions are also still about the pandemic situations. We believe that these pandemic situations give so many impact on the drafting or implementations of the contract that we should consider in the future. Maybe I'm coming with the questions from Isar. Since the COVID-19 pandemic is the new phenomenon, can the COVID-19 pandemic be deemed as a hardship situations, or this pandemic constitute as a force majeure? Prof. Anna.
So excellent question. And if I may, again, I would like to refer to something that UNIDROIT has recently produced, which is a note, a secretariat note on this special question, on the application of the UNIDROIT principles rules of force majeure and hardship to the pandemic situation. This note is freely available on the web, and I will be very happy to share the link to it after this lecture. And it does look in much details to different situations, because what we have to say is that the force majeure application of the force majeure on the one hand and hardship provision on the other are highly dependent on the circumstances of each case, because you have to look at what is the meaning of foreseeability, of what is the meaning of unavoidability, and therefore this has to be seen in the circumstances of the case. And the note gives some examples and tries to solve very concrete situations, looking at different times of the pandemic and different types of contracts and so on. So if I may, I can refer to that. And to what Dr. Prita has said, I totally agree with her that the pandemics actually in legal terms has taught us something. There will be something that we will continue to look at and apply also later on, which is this idea of having a better way to approach the very varied and different possible disruptions to contracts through well-crafted clauses and also to well-developed laws in the future. So yes, thank you for pointing this out.
Yes.
Maybe
Prof. Hamza. Okay, so maybe about not even the hardship, Prof. Anna, in terms of the force majeures, we could not directly deem the COVID-19 as well as a as a force majeure, because in Indonesia there's also some discussion on that. Does the COVID-19 could also directly deem as a force majeure or not? Different situation, we have to learn the conditions or the cases to what extent that we could deem COVID-19 as force majeure. And after that, with the hardship. So I think the idea is in terms of in Indonesia, we have to learn further to what extent the difference between the force majeure and the hardship, and also to what extent that we could deem the conditions or the cases as a force majeure and hardship. Maybe that would be really interesting. The students or the participants could also take a look what Mr. Hamza has already shared to us, the note of the UNIDROIT about the COVID-19 conditions. I think it's literally interesting to learn. So I think this is the end of the sessions of the discussions session of the International Public Lecture. Before we move to the next agenda, we would like to request the closing remarks and maybe if you want to have something or do you have something message for the student, Prof. Anna or Mr. Hamza? Prof. Anna, please.
So first of all, again, let me say how honored and delighted I am to have had the opportunity to participate in this lecture together with my colleague Hamza. If I may distinguish, institutionally speaking now for UNIDROIT, Indonesia is a very cherished member state. We're very happy to have a stronger lean and cooperation, in particular, as the Dean said, with your university, with your department. So let's go on with that. Let's continue to have this cooperation and enlarge it, because I see that we have many possible points in common to develop. So I can institutionally say that we are very happy about this possibility. Institutionally, again, happy to receive scholars, students from Indonesia in all the possible ways that we facilitate this participation, and also, why not, to organize a consultation or other events that may explain the instruments of UNIDROIT to a wider public, and maybe also be able to answer questions, comments, concerns. So something may be tailored really to the Indonesian situation. So we learn from you, and we hope that we can give also something to you. More generally, as a professor, I'm so happy that there was such a very active participation by my colleagues, faculty members, but also by the students. You are very fortunate with your students, and so let's keep up the good work. Hamza?
Thank you very much, Anna. And I'd only reiterate everything Anna said. We're very grateful to your university for kindly inviting us to deliver this joint lecture. And then the interest in this lecture was incredible. At one point, we had almost 250 people in the room, and we're very honored that 250 people came to listen to us. And we're very happy to be speaking at this university right now remotely, but hopefully sometime even in person in the future. Like Anna said, not only is Indonesia a very important member state for us, it's also one of the fastest growing economies in the world. And UNIDROIT's instruments promote more international trade, cross-border finance, and better commercial law practices. So to further the understanding of instruments such as the Cape Town Convention and the UNIDROIT principles amongst academics, young lawyers, and practitioners in Indonesia is 100% part of UNIDROIT's mandate and mission. So we were very happy to have this conversation with all of you. And I'm incredibly grateful to the Dean, to Professor Prita, to the Master of Ceremonies, and to my dear friend Taufik, who kindly invited us to do this. Thank you.
Thank you very much, Prof. Anna and Prof. Hamza, for the closing remarks. And I think this is very important that we have a note, Pak Taufik, from Prof. Anna, that we have to continue the collaborations after this event. And looking forward to that. I think we are from the Transnational Business Law Department. Is very an honor for us, and also a great opportunity for us to have a collaboration. And maybe we could arrange another program to support what UNIDROIT have, and as well as to support the academic activity in the Universitas Padjadjaran. And once again, on behalf of Dean, Faculty of Law, Universitas Padjadjaran, we would like to thank you and appreciate for these collaborations, and hopefully we could meet. Maybe you can visit us in Indonesia, or maybe we could elaborate or arrange another program in the future. And Prof. Anna and Mr. Hamza, I believe that all the participants, student has an inspiration to have a research related with what UNIDROIT has on the hard law or the soft law. And we are looking forward to learn further about the instruments and what you share in the website, as well as with the link that you share in this event. Once again, for all the participants, thank you for all the participations, and maybe this lecture could be accessed in our YouTube channel, Transnational Business Law Digest, and looking forward to welcome you again in the next event. Next Friday, Prof. Anna and Mr. Hamza, we have the session with the UNCITRAL. We discuss about the conventions, international sales of goods. Once again, thank you very much for Prof. Anna and Mr. Hamza for the lecture and your valuable time to meet with our student as well with the participant. Pak Bayu, thank you so much. Pak Bayu is my mentor about the UNIDROIT, and we share the knowledge about the UNIDROIT principles on international commercial contract or the other instrument. Thank you for all the committee for all the students, especially for Pak Taufik to make it happen, to connect us with the Prof. Anna and Mr. Hamza, and Pak Mursal, Bu Helita, and all the lecturer that attend this webinar. Once again, thank you. Before I give the session to the Master of Ceremony, we would like to extend the appreciations by extend the certificate of appreciation from our Dean. Maybe the host could show the certificate. Thank you very much for Professor Anna Veneziano for the time and the lecture, and also for Mr. Hamza Hameed. We are from the Transnational Business Law Department, looking forward for the next event.
Thank you so much. Thank you.
Thank you.
Thank you very much.
Bye-bye. Bye-bye.
Thank you. And I back to you, Adiana. Thank you, Prof. Anna and Mr. Hamza.
Bye-bye. Bye-bye.
Thank you very much for amazing speakers, and also Madam Prita Amalia for becoming the moderator for today's event. To all participants, this webinar has come to an end. On behalf of the host, I would like to extend our greatest gratitude and appreciation to all speakers, moderator, and all participants for being able to participate in this webinar. During this webinar, it is inevitable that we made some mistakes. Therefore, we would like to apologize for the mistakes we have made. I, Adiana Bella Putri, as your master of your ceremony, would like to say thank you very much for being present in this today's webinar. We wish you a great day ahead. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi Santi Om, Namo Buddhaya, best wishes for all of us.
Thank you. Thank you so much, Prof. Anna and Mr. Hamza.
Thank you, everyone. Bye.
Thank you.